Professional crime is one in which crime is committed in a specialized way with a prime motive of economic gain. Professional criminals who commit crime as a regular business use techniques which have been developed over a long period of time and transmitted to them through personal association. What is important in professional crimes is a skill in which crime is committed. Persons who are engaged in professional crimes have the skills and means to attain the criminal activity and specialize in some particular type of crime such as theft or swindling. The concept of professional crimes, however, developed primarily in the United States during the latter half of the 20th century. It proposed the existence of a population of habitual offenders whose approach to offending included a degree of organization, speculation, repeated offending, and specialism into certain forms of criminal activities. These criminals, however, came among from the non-working or the declassed elements of society, and the most common form of professional crimes were banditry, smuggling, speculation, swindling, and buying of stolen goods. It is in these advanced arrangements, quite as much as in the technique of executing the crime, that professionalism is found. Moving on to the definition of professional crime. There are no static definitions for professional crimes, but however, one of the leading scholar, Edwin Sutherland, in 1930s and 1940s, argued with respect to two main key elements of this phenomenon, that is the status of offenders and the methodology of professional thieves. However, Sutherland gave 6 characteristics of professional crimes. The first one is regularity, that is continuity in a work as a crime. Secondly, technical skill for the commission of a criminal activity. Thirdly, status of the person. Fourthly, consensus, sharing of common values and beliefs with other criminals. Fifth is the organization in groups committing the criminal activity. And finally, differential association. With respect to the differential association theory, that each criminal is associating with other professional criminals to the exclusion of ordinary criminals. These are the 6 main characteristics of professional crimes that has been given by Sutherland. Moving on to what is a moral turpitude, to know about an act of moral turpitude. Moral turpitude is nothing but an act or behavior that gravely violates the sentiment or the accepted standard of the community. It was defined by the Black's Law Dictionary as any act that is of baseness, vileness, or the depravity in private and social duties which one man owes to his fellow men. Under IPC, there is no proper definition of moral turpitude in IPC, but one of the famous case, Mangali vs. Chakilal and others, the court lordships gave the following propositions for determining whether an act constitutes moral turpitude or not. Firstly, whether the act leading to the conviction would shock the moral conscience of the society. Secondly, whether was it a base one. Thirdly, whether the perpetrator could be considered to be a man of depraved character. If the following conditions are satisfied, the lordships held that it would constitute an act of moral turpitude. The main offense and the main crux of this topic is with respect to the offenses under moral turpitude. Moral turpitude, as we just spoke about, is any act or behavior that is going to be against the accepted standards of a community. All the offenses that are against the public in the society, as well as certain offenses which are listed under Indian Penal Code, would fall under offense of moral turpitude. This would include like murder, theft, perjury, bigamy, rape, outraging the modesty of women, compelling a woman for marriage, selling her for prostitution, and etc. Under Indian Penal Code, under Schedule A of IPC, certain offences are considered to be constituting an offence of moral turpitude. However, they are also professional crimes because once when it is high and grave that is going to be against the society, it also involves a professional skill and professional organization to commit it. So that is where comes the relationship between the professional crimes and the moral turpitude. However, under IPC, we have Chapter 11, 12, Chapter 16, Chapter 17, Chapter 18 and Chapter 20. All the offences have been mentioned clearly in my PowerPoint, but I will just give a crux of this offense. Chapter 11 with respect to fabricating evidence, Chapter 12 with respect to counterfeiting coins, Chapter 16 from Section 302 to 377 of IPC with respect to murder, culpable homicide, miscarriage of women, outraging the modesty of women, kidnapping, abduction, selling for prostitution, and etc. Chapter 17 deals from Section 379 to 420 with respect to offences of theft, extortion, dacoity, robbery, criminal breach of trust, and cheating. Chapter 18 with respect to Section 465 to 489E, offences like forgery, counterfeiting currency notes, possession and making of such notes. And finally, Chapter 20 of IPC, Section 497 and 498 with respect to committing adultery or enticing a woman who is married, are offences of moral turpitude. All these offences are against the society, and they are also act or behavior that's against the accepted standards of the community, and they are base and vile. So these are all offences of moral turpitude under Indian Penal Code in India. The main study which I have done is what is the relationship between the professional crimes and the moral turpitude as a case study. So professional criminal activity is an illegal activity of the person possessing corresponding experiences, skills, methods and instruments, persons considering this activity as basic occupation and main or additional source of money income. Criminals quickly adapt to new kinds, forms and methods of entrepreneurship. They use conditions of developing market and new technologies as criminal purposes. According to A. Guroff, criminal professionalism is nothing but a criminal occupation as a source of means for the criminal. It demands necessary knowledge and skills for achieving the ultimate goal. It causes certain contacts with antisocial environment. It defines a stable kind of criminal occupation. And finally, criminal professionalism gives an opportunity to prepare, commit a crime and cover up traces, and as a rule to avoid the criminal liability to have a constant income. When we talk about the elements of professional crime, there must be some amount of dedication and devotion for the purpose of the crime, as the main motive is finance in these crimes. They have enough skills and techniques to acquire their goals. This is where we have to talk about what is the relationship with professional crimes and moral turpitude. To know the relationship of professional crimes with moral turpitude, we have to know what are the crimes that are done in a professional way, on the other hand that cause offense of moral turpitude. Some of them which I'm going to list under are: first is murder as per 302 of IPC. It is done professionally with an intent, an act to willfully kill someone, but done in a skilled and a technical filled manner. Since it's depraved, it is also moral turpitude. It's also against the societal norms. So actus reus and mens rea both are present. That is why murder is one of a professional crime and an act of moral turpitude. Secondly, we have voluntary manslaughter. We have third, felony hit and run. We have spousal abuse, child abuse, which are done with the intent to do it and also against the accepted stance of the community. We have drug crimes like drug trafficking, drug abuse. We have cruelty to animals, kidnapping and abduction of women under IPC, fraud, theft, robbery. All these offences under IPC are against the accepted stance of community and they are depraved and vile in nature. So these are all offences of moral turpitude and they are professionally done. That is why the relationship comes with respect to professional crimes and moral turpitude. In the new emerging world, computer crimes are the new species of professional crimes, and with the emergence of technological inventions, computer crimes are growing monetary goals of the professional criminals. I have listed a lot of case laws in my PowerPoint, but I will just highlight two main case laws. One is Kuldeep Singh versus State of Punjab, where the court held that killing a person is an act of self-revenge and an act of personal vendetta. Per se, an act of murder will not come under the meaning of moral turpitude. In this case, murder is a professional crime with ideas and technology, but it does not constitute an offence of moral turpitude. However, what constitutes an offence of moral turpitude was given in the case of State Bank of India and others versus Supramanian. In this case, court clearly held to qualify a crime as a moral turpitude, it requires both reprehensible conduct and scienter, whether with specific intent, deliberateness, willfulness or recklessness. So court held that it was difficult to classify such hurt as offence of moral turpitude. Hence, in this case, Supramanian was discharged, but the main guideline that was given was there has to be specific intent, deliberateness, willfulness or recklessness. So personal vendetta or self-revenge will not come under an act of self-revenge will not come under an act of moral turpitude because it comes under private defense. Moving on to settlement of offences involving moral turpitude, there was one of the important case that was being held by Kerala High Court in Binu B. Bhaskaran case. In this, there was a petition that was being put by Binu B. Bhaskaran in front of the court where he was being charged with an attempt to commit culpable homicide. He requested the court to quash the petition because he has already come to a settlement with the de facto complainants. But the court clearly held an offence involving moral turpitude is essentially one affecting the public at large, and the state is not only the prosecutor but the complainant also. So when that is the case, whatever be the settlement initiated by the accused, it will not be held valid in the eyes of law. What are the legislations that cover professional crimes and moral turpitude? So as it is very well clear that moral turpitude are mainly offences that gravely hurt the sentiments of the society. These offences are serious and they have to be regulated and punished. That is why there are certain acts that are present in India that are to control such offences and regulate such offences. The very first one is Indian Penal Code of 1860. So Indian Penal Code does not define the word called moral turpitude, but it has adequate provisions to deal with offence of moral turpitude, to give punishments and to regulate these offences. Where we read about all the offences of murder, dacoity, robbery, theft, kidnapping, all these offenses do have their own regulating provisions and their punishment provisions. Punishment can be with imprisonment of 2 years till imprisonment up to life. So all these are very well applied in India in order to control the professional crimes from happening. Secondly, we have UP Municipal Corporation Act of 1959. In this, if a corporator is convicted of any offence of moral turpitude, he will be removed. And we have Constitution of India 1950, where a president or a vice president or an electoral office cannot hold office if he is committed as an offence of moral turpitude. And we have the UP State Universities Act of 1973, where the university court has to remove any person from membership of any authority or body of the university if such person has to his credit a conviction of an offence of moral turpitude. And we have the National Council for Teachers Education Act 1993. In this, a member of the National Council shall be disqualified if he is convicted and sentenced to imprisonment for morality-related offences. We also have the new emerging crimes, like we have prostitution as a professional crime, for which we have a lot of acts that has been come about, out of which one is the Immoral Traffic Prevention Act 1986, with respect to preventing and abolishing prostitution by criminalizing such acts. We also have drug trafficking as one of the important criteria. So we have Prevention of Illicit Trafficking in Narcotic Drugs and Psychotropic Substances Act, in prevalence to control trafficking on drugs, import, export, selling of illicit drugs. So this is also a professional crime in the current emerging world because of the growth in science and technology. Drugs have been easily been exporting to another countries in an immoral and an illegal way. So all these are professional crimes, and there are a lot of legislations that has been brought about the above following ones to control and to regulate these professional crimes. What are the emerging areas that come under the concept of professional crimes are mainly with the growth of science and technology. So we have drug abuse as one of the very important professional crime that's happening. So we have a lot of drugs, like major ones like heroin, we have hashish, opium, cannabis, meth. So all these drugs are not allowed and they are not legal in many of the countries. So in those countries, criminals start to consume all these drugs through illegal drug dealers and start to commit crimes. So these professional criminals have adequate skills to perform drug abuse and sell these illicit drugs in the world trade. We also have smuggling and smuggling of the goods, and we also have the new concept that's computer crime. Computer crime is one of the important professional crime that's currently happening. So to know if a particular crime, professional crime and moral turpitude is present, first there has to be professionalism in the crime with what intents it's created. Second, it must deprave the morals of the society, and it must have recklessness and depravity involved to cause a moral turpitude. These two are very important to determine whether an act is professional in nature as well as it should cause an act of moral turpitude. I would like to conclude my study with saying that it's however ironical to say that every offense of professional crime is an act of moral turpitude. This is so because professional crimes are so heinous and grave as it involves a series of ideologies, techniques and skills which have been done with intention and preparation, with the outcome it is thereby affecting the sentiments of the society at large. However, it ends up causing an act of moral turpitude. Various legislations are prevalent to regulate professional crimes and to provide punishments and reformation of criminals, but with the growth of cyberspace, growth of science and technology, it has led to triple the amount of professional crimes as it paves way for purchasing tools and associating very easily with criminals and gangs. I would like to conclude this with quoting the Sutherland's theory in some way, because the Sutherland's theory of differential association says that every individual in this society ends up associating with one another in some or the other way, paving a very big pathway for creating professional crimes. Various efforts have been taken by the Indian government to abolish professional crimes, but they have not been controlled completely. They have been very much prevalent, and very much efficient methods have been brought about to regulate and punish such criminals, such that it does not go away in one hand and it will get punished in the courts. So in some way it is controlling the professional crimes from happening, and it also has made efficient efforts in order to regulate and punish such criminals. Thank you.